A toxic Superfund site in South Asheville is getting national attention. A lawsuit filed by residents against CTS is now set to go before the U.S. Supreme Court. News 13 investigative reporter Mike Mason joins us. And Mike, the outcome of this case will have a nationwide impact on people who sue companies accused of contamination.
Well, it certainly will. This case will determine how long people have to file a lawsuit. Victims feel they should be allowed to sue when they find out they're sick, even if it's decades later. Corporations say there needs to be a time limit. Residents living near the old CTS plant say they're still suffering from exposure to toxic chemicals used by the company 30 years ago.
One of my tumors, I couldn't speak for 4 months. Of April of '99, my husband had been diagnosed with a brain tumor.
In August of '98, I was diagnosed with CML, which is chronic myelogenous leukemia.
Kent Stahle grew up next to the CTS site. He moved away for most of his life, but recently returned.
News 13 investigates the whole story behind a toxic Superfund site in South Asheville.
After watching a News 13 investigation last November, he felt his cancer could also be linked to CTS.
Yeah, I saw a little segment that you were doing buried secrets on the CTS plant. First I'd heard of it.
Stahle now hopes to join dozens of other residents who filed a civil lawsuit against CTS, claiming the contamination hurt both their health and property values. That case is now going before the U.S. Supreme Court. The question is whether this case exceeds the statute of limitations. According to federal Superfund law, time begins after a person finds out what caused their injury.
They wanted you to have notice that you were hurt and who had hurt you before the statute of limitations began to run.
Attorney Joseph Anderson represents those suing CTS. He says the Superfund law protects people like Stahle who didn't know about the contamination or his cancer until decades after CTS closed its Asheville plant. But CTS's attorneys say this case should be dismissed because North Carolina has a statute of repose which states people only have 10 years to sue a company, even if they develop health problems later in life.
What CTS is arguing is that the statute of limitations can run before you even get hurt, and therefore CTS walks away scot-free.
On Monday, the U.S. Department of Justice filed court documents supporting CTS, stating the U.S. has a substantial interest in the proper resolution of the CTS case because of ongoing litigation against the U.S. involving allegations of contaminated drinking water at Camp Lejeune.
This case is important. It sets precedent. It can affect the entire country, and I think it's going to have a big impact on the development of the law and other people's potential claims.
The Camp Lejeune case alone involves thousands of former Marines and their families. Their lawsuits are now pending, awaiting the outcome of the CTS case. Ironically, the Department of Justice is currently supporting CTS in this case while opposing it in another. In a separate case, CTS is challenging the EPA's decision to place the Superfund site on the national priorities list. The U.S. government has been defending the EPA in that case since 2012.
And that doesn't seem right.
Laura Carson is one of the original plaintiffs in the civil case.
Right.
In 2005, she bought a high-end condo at Southside Village adjacent to the CTS site.
I would not have bought here if I had any idea that was a contaminated site over there.
Carson never thought her backyard would now become center stage for such an important issue.
What's at stake here is literally millions of future latent injury claims.
The case against CTS is set to go before the Supreme Court on April 23rd. A decision is expected by June. Despite numerous requests, CTS officials have refused to speak with us.